Yes. May I be permitted to seek your lordship's leaves to file one application appeal, my lord, without certified copy?
You have given the undertaking.
Yeah, yes, my undertaking will be in the this stay application, my lord, because it's memorandum of appeal, my lord, only containing the grounds.
What is the system? I don't know.
And that's the system.
Whatever is the usual
Your lordship
system
court
you follow.
officers know, my lord. The undertaking is given in the that I have to give that.
Why don't you give a letter kind of an undertaking?
But that's not the process or the procedure. My lord.
Anyway, whatever is the procedure, you give the
Procedure
undertaking.
is to that the endorsement is to be required.
What is the date of the order?
2nd July, my lord. Immediately on that day, I applied, my lord. Till date, my lord, it has not been supplied, my lord.
Very well, file.
Great, my lord.
My lord, may be permitted to mention for inclusion, my lord. My lord, this
Give
is
the inclusion you may give. It will come in the list. August list, it will come, monthly list.
my lord, there is an apprehension of contempt matter may be filed in the meantime. So I'm mentioning. that.
Whenever that apprehension is precipitated, you come. Don't worry. Call.
Item number 1.
Your Lordship, appear on behalf of the petitioner. Affidavit of service.
আমার পাশে যে আছে আমার আর চিন্তা নেই
আরেকটা কপি
এটা তোমার বই না তোমার
না।
মারি কাল না হলেও আমি রাখি না এগুলো সব
What happened in the recruitment process?
Your Lordship, in this matter, the petitioner appeared in the recruitment process according to advertisement number
What
20.
happened, sir? That recruitment process is over.
Yes, Your Lordship.
So how now can we rescind it or recalled?
Your Lordship, in the recruitment process, they have not disclosed why the petitioners has not been chosen, even though
How where they can disclose, where they are obliged to disclose why you are not chosen.
the petitioner has made 3 RTI applications in that regard.
Keep making RTI application.
Your Lordship,
2006 selection process, when the recommendation? 16, yes.
Then OA was filed in 2025.
Mike.
I am raising the.
Your Lordship, in the meantime, there have been filed 3 RTI applications which were pending. They have not replied to it. The petitioners have also approached the second appeal, and even there has been no clear answer. Your Lordship.
What is the RTI information that you are seeking?
Your Lordship, we have seeken for the specific reason for why he has not been chosen. No, Your Lordship. In the written examination he has passed. Your Lordship, in the personality test he has passed.
So
They have discerned ki on the basis of the interview, only on the basis of the interview.
why not? Many like you have been
Your Lordship, this is my
Consulted.
kind submission that only on the basis of an interview
Sorry.
process.
no, you said after examination interview was conducted. Don't say only on the basis of interview process. That's a wrong statement.
Your Lordship, in the interview process,
So interview was also qualifying.
but they have only taken the interview
Whatever
process.
it is, those were the terms of advertisement. Knowing that it was going to be conducted in that way, you have appeared. Because you have not been selected, everything has become bad.
Your Lordship, in the advertisement
It's
itself,
every day the same thing is being filed.
Your Lordship, in the advertisement itself, they have not stated that the interview process in the last stage would be the only reason.
Then why did you not challenge at the time of interview?
We have challenged at the time.
At the time of interview,
Your Lordship, petitioner has.
yes, you will. Whenever you wake up, it will be done. When the recommendation was made, what is the date?
Your Lordship,
It's unnecessary. This is appears to be a frivolous litigation to begin with.
দেখো ও খুঁজে পাবে না পেয়েছি
Anybody who is not selected will say that everything was bad.
Yeah. What is the date of this annex? Page 60. What is the date? Page 60.
Page 60.
60.
The advertisement. And program. We can also application.
The last date.
এগুলো তো application.
এটা published হয়েছে তো সেটা দেখা যায়।
When the result was published.
That was published.
Yeah. Matter of penny.
I think they don't
No. Wait, that it. ওটা তো
যখন
না ফাংশনে করে না কিন্তু ওটা ভিডিও করে এখানে ফাইল করতে হবে
সেটা করতে
সেটা তাহলে ওয়েব পেপার ইন্টারফেস সাইজ না কি করে তো সেটা জানবে না নিয়ে এখানে না বলি
ওখানে রেজিস্টার
রেজিস্টার তো বলতেই পারে যে
আপনি
কোনটা
Your Lordships, if you allow me to make one submission before your Lordships. In this matter, your Lordship, the main issue of the petitioner has been that he has secured the required marks as suggested by the respondent authority, the recruiting authority, And even after that, they have dismissed his recruitment on the basis, just on the basis of the interview, for which we have also filed an RTI. And on the basis of under section 8 subsection 1 of the Right to Information Act 2005, they have rejected to disclose that fact. And that is our main point of challenge, Your Lordship. And this inadvertent delay that has been caused has been due to the delay in the RTI process, Your Lordship. The petitioner has not been sitting silent. He has been processing RTIs, he has been attending the hearings, but to no avail. He has finally got the list of the mark sheets, which were for the personality test and the written test, which is at page 130, Your Lordship. And at page 128, Your Lordship will find the response of the Public Service Commission West Bengal to the RTI dated 19 of June 2024, given on 8 January 2025, in where in the point 2 of the query, they have stated that they are unable to disclose the interview panel members' marks given in the interview under the section 8 subsection 1 of the RTI Act, Your Lordship. This is our point of challenge, Your Lordship. On the basis of just the interview process, they have alleged that the petitioner is not uh, eligible for the recruitment, Your Lordship. পরে হয়েছিল বলেছে আরটিআই রিপ্লাইতে বলেছে যে উই ক্যানট ডিসক্লোজ ইন্টারভিউ হয়েছে বলেছে
Could you get the date of the advertisement? What is the date of the advertisement?
advertisement date is on page 59, your lordship, the advertisement.
What is the date? We have not been able to find the date there. Oh, 59.
59, page 59.
Well, January.
For one week only in order to accommodate applicant to apply level
From 12/1/20.
those immediate interview.
Page 128, interview not disclosed.
Executable
That personality test is not the interview. That is different. Both are different.
Yes.
Information gives the petitioner short for
No, that we are not concerned with. This is not an appellate authority for the RTI. That we are not concerned with. Whether he got or he didn't get, that is for him to approach in a different jurisdiction. Here he is questioning the result. He is questioning.
got the number. What is his number?
Yes, we are looking at it. It is there at page 130.
Yes, sir. Got
We are looking at his marks.
and some 128 Public Service Commission has informed that why you should not give the question. The query is that please provide for.
No, we are not concerned with that. That's not the concern of the either the state administrative tribunal or the writ court. Whether he was allowed the proper information under RTI, that's not the scope of these proceedings. For that, he has to go up to second appeal and then an appropriate proceeding, not in before the state administrative tribunal. He is saying you cancel the entire exam, the entire selection. Yes, impossible.
All the
Take down. Heard the advocate for the.
Required number of marks, the personality test which has been mentioned in the advertisement, he has also he has required the marks that was needed for the qualification. Then in the interview process alone is where he has been disqualified. And to that effect, when the
After
petitioner-
personality test, there was interview.
yes, your
Where have you stated in your OA? Just show from your OA.
Sir, Your Lordship, at page 40 of
Read, what is the date of the interview after personality test? Why you make a factually incorrect submission?
I apologize, Your Lordship. It's not.
Why you make a factually incorrect submission? That's not expected from any lawyer. You put us in embarrassing situation. There are many things we don't want to say, then we'll have to say. Take down, heard the learned advocate for the
Item number 2, no, my lords. And number 2, my lord, I think this has not been served upon me. My lords, I will just indicate that there has been a change of advocates. There has been a change of advocates, your lordship. This is a 2024 review. I am the review applicant. Now, my lords,
What is CAN 2?
my lord, if a copy may be given to me, but I am not aware of CAN 2, my lords. Madam, CAN 2.
What is the CAN 2?
Granted DPR vote, they are in house. And order order passed on 7th of order.
No, what is the CAN for? We are asking.
But last one, 20. The white starting copy of the Calcutta order to second order the copy of the Calcutta order, then the office informed that the given application filed by the applicant is already we are not something copy. Copy of the review.
I'll do that. Your lordship, kindly. No, that's what I'm going to submit, your lordship. Kindly grants me 2 weeks time, my lords. My lords, this has changed me what I was.
You are the appellant. And the application for divorce was filed by the wife, by the husband. It was allowed. Yes, so what is the review you want?
No, my lords, since all the cost papers are not available yet, your lordship, to me, this is a changed brief, your lordship.
That we don't encourage such submission.
My lords, only
If you take the brief, you take all responsibility. We are not obliged to give you time. That because there is a change, if you will get a time. We don't
I apologize, my lords, for that.
Don't say
My
this.
lord, only the few cost papers are missing, my lords. I'll just get it within few days, my lords. Kindly, this matter has come up in that instance. If your lordship kindly grants me 1 week's time, my lord, I'll come back and
Give him a copy of the application.
can do, my lords. This has been served on the claimant. However, I have not received it.
We
That's
don't
what
want to
is the
get
change
into
of-
that. If you are interested in consideration, give him a copy. Otherwise, we'll see one. As prayed by.
एक question जो like
Item number 3.
Hello, I am for the petition applicant.
Yes. Tell us, what is the case?
My lord, according to my little bit of knowledge, my lord,
Yes.
there are the differences of the two division bench order. So my submission is this, my lord, matter to be sent to the larger bench. Kindly come to, my lord, the impugn order, page 170. Page 170. My Lord Justice Samudra Chakraborty, as his lordship then was, he dismissed the writ petition in the first instance without affidavit, considering of the judgment of this Honorable Division Bench, my Lord Justice Nishita Mahatre and my Lord acting right now, the acting Chief Justice Tapobrata Chakraborty. On the basis of that, writ petition dismissed. When in the writ petition, I have annexed the another Division Bench order passed by Division Bench presiding over by my Lord Justice Ashwin Kumar Banerjee.
Yes.
My Lord, this order, impugn order, page 170, passed by my Lord Justice Samudra Chakraborty as his 170 of the stay petition.
No, we are going through your petition.
Yes, but
When you retired, how many years you worked? Who are you? Where did you work?
1998.
Where is this statement in the writ petition? Please show.
No, that is not here. Because I cannot.
Then of course, something which your client has said.
No, but is that I was the employee of CSTC.
Very well. That's all.
No, kindly come to the judgment on the basis of who is the learned senior.
Required. We are asking you, show the details. Forget about judgment. We are sitting in division bench. You show us.
Yes, my lord, you are sitting in the division bench.
Yes.
I know. Question is this. When the
Question is this, you raise a plea for pension.
yes,
The writ petition, there is not even a whisper. How you when you get on which post? How anything can be given to you? That is the question. You tell us. That is the only question. Which
Another-
forum will come later?
subject to my lord kind permission, I make a single submission.
Yes.
Yes, that is not here.
Then
Then
what can be given
question
to
is
you?
in the sales and matter the union union of the company CSTC, they have filed application and they have given
Very well.
direction to remove the pension.
Very well.
And another judgment is there. The question is this: when SBTC is the industry,
That is not, we are not raising that issue. You need not go there. You need not go there.
my lord
We
should
are asking you, we are sitting here to
my
see.
humble submission before lordship that my lord should have, because on the
Very well.
sales and issue the order was in first division bench.
We will
Another division bench says
we will consider that submission. We will consider that submission. We are asking you, how can you maintain a plea whether a tribunal or right court in absence of any detail, what is the question of any claim being made? Not a whisper. The petitioner 1, 2, 4, and 5 are ex-employees. Petitioner number 3 is wife of an ex-employee. How, from which post they were?
I have filed,
Nothing.
I have filed the application for appropriate order at can number 5 of 2026
Yes.
that the petitioner number 3 in the writ petition has not approached, neither forwarded any names of legal heirs. So what about when I filed the petition against the with respondent 3? Dead man cannot be filed.
Anyway, that is not issue. There is no detail. Nothing can be granted by any forum. Forget about industrial tribunal.
Writ petitionটা কোথায়? Writ petitionটা?
Rate petition is at page 50. We are telling you, come to page 50.
My lord is first reader.
50 to 72, all your pleadings, we have gone through. Not a whisper regarding anyone.
Petitioners are the employees of the
Very good. That's all right.
Petitioner number 1, 2, 4, 5 are the retired employees.
Yes, and 3 is wife.
And 3 is the wife.
Yes.
Legal notice টা কোথায়?
You're for the corporation or you're for state? Yes, sir. Enough is enough.
No,
No, enough is not enough.
enough is not enough because there is much more enough.
Yes, then we are asking you, don't, please say whatever you want to say.
Yes.
We are not going to wait all day.
No, I also don't want.
So therefore, we are saying, tell us what you want to say. We have heard you said that it should be referred to a division bench. We have heard you said that others have been granted. Now tell us what else submission.
Kindly come to 156.
156. Yes,
Kindly come to para 3
yes.
of the demand justice.
One 36.
157. 156.
153. Yes.
Para 3.
Yes.
My client has preferred application of payment of pension to opt retirement, but your authority has not released pension to my client.
Yes, we have,
Submission is this.
we have,
Second, the matter seriously right now. It's a said that says, it is the duty.
all right, that is your,
That it is the sole that this
we are not here to answer your questions. We are not here to answer.
I am also, I only saying my lord has given me the permission.
Yes, so that is your fourth submission. Now fifth submission.
Only this.
Very good. Take the third, the learned What?
My lord, these documents, the details. My lord, if you have filed the supplementary,
Sorry, call the next case.
item
Item 4, my lord, I am appearing for the petition on my lord, last occasion, my lord, on by letter dated 14th July 2026, my learned friend, my lord, was pleased to, my lord, send a notice with a prayer to supply the reply, my lord, which has been filed before the tribunal. But I have informed him that no such reply direction was given for filing reply and rejoinder. Therefore, it is not.
The tribunal reply was filed.
No reply file. There was not given any direction at all to file reply and rejoinder.
It is pending or it is disposed of.
We disposed of, my lord. And last occasion, your lordship was pleased to direct, my lord, to the learned advocate, my lord, even earlier state advocate, my lord, to file the report against
Okay.
the, my lord, paragraph 9, my lord. Kindly see the order dated.
So let us see what has happened. Yes.
Kindly come,
Just wait. Yes.
my lord.
Please wait. Please. Yes.
My lord.
Yes, we remember. We have picked up one small point and we have asked.
Assertion made in paragraph 9 of the reply.
Yes.
So that is why we were looking for the reply. We didn't get it. It wasn't served. But now my learned friend has said that there was probably there is some mistake in the order of
Which order? Let us see.
Order dated 12th of February. I have repeatedly prayed for time for getting this specific.
So where is this paragraph 9?
My lord, I have placed, my lord, before your lordships the regarding the matter, facts and circumstances. Your lordships pass such order, my lord, regarding paragraph 9. Actually, several times I tried to, my lord.
No, we have gone through the matter. We remember.
Yes, my lord. Yes, my
We
lord.
saw that there was
Yes,
it
my
was a
lord.
very steady claim.
Yes, my
If
lord.
we remember correctly.
Matter
We
is.
saw that there was some direction of some court.
Yes, my lord. Reply was given by the state authority, my lord.
Where is that reply?
Yes, my lord. I am coming there, my lord. Kindly come to page, my lord. Page, my lord, 143, my lord. Pursuant to the, my lord, application made by the petitioner, actually when they will conduct the recruitment process in.
Correct. Where is that?
Yes. Kindly come, my lord, page 143, my lord.
143.
143 and fresh copy another, my lord, 144, my lord.
143 of which?
Because 21st July 2010, my lord, they rejected the pen.
Please show us the document first. You keep saying whatever you want. We don't understand anything.
Page 144, my lord.
We are not able to locate it. Please show us which. It is in an affidavit in reply. It is in opposition. Where is this?
This was, it is in the, my lord, OA application, my lord.
OA.
Yes, my lord. Hold on.
(143) Annex J.
Yes, my lord. 43, it is eligible, and 44, my lord, fresh copy, another copy, my lord. Another applicant was given the said same reply, my lord.
That is not the correct. You don't remember on what document we relied, and we should remember. Because after that, there have been 2 or 3 adjournments.
Civil matter was adjourned, my lord.
For getting the specific instruction.
My lord, if your lordship kindly come to page 104 for a moment, my lord. Regarding which this reply was given, my lord.
Then the reply.
Yes, there is a reply. There is a reply on record. Why you are saying there is no reply?
My lord, kindly see the my lord, have lordship got it, my lord, 104.
Reply before the tribunal. There is a
This is
reply.
not reply, my lord.
There is a
My lord, recruitment process was started.
there is a reply. You speak over us, that will not.
For my lord, my respectful submission.
What is this?
This is the my lord reply against the WPST, my lord.
Exactly. So there is a reply.
That has already been.
Paragraph 9, you read of the paragraph 9 of that reply. You see page 5 at the bottom where the Supreme Court order is quoted.
Like sign before the tribunal.
That we have understood, there may be an error in that order, but this is where we have seen it. There was a direction, the High Court affirmed, Supreme Court also said that issue letters and all these things. So therefore we ask what steps you have taken. So it is in response to this that you have to give the. Yes, we are informed by the learned AG. Yes, call the next.
Item number 5. Item 5, my lord, I appeal for the petitioner. The matter relates to, my lord, you may recall the virus of the act, wherein the candidates have been completely sidestepped in the recruitment process. My lord, the Kolkata police authorities, like, could I recapitulate all Lordship straight away go to the judgments and all things? Lordship has heard me many a times on this matter.
We have heard you many times, but we don't want to take it up today.
I leave it to Lordship. Any day, time may be fixed at 2 o'clock, any day.
Yes, then only it can be done. That's why we are saying.
As a Lordship says.
In the next week, when can we have it at 2 p.m.? Next or next to next week, 2 p.m. Clear. Disposal of
Item number 6.
6 pallet.
I'm for the writ petitioner.
Like a director be part of it.
No, that I have already served. Even if you required, I will serve. No issues.
The learned state.
Well, may I pray one? Well, since the interim order is going to be expired on 30th.
You need not. Once we finish the order, you tell us. What is the date? List on 7/8/2026. The
People.
Item number 7.
This matter, we appear on behalf of the state, my lord. The last operation, my lord, has specifically directed to file our affidavit as last chance, my lord. My lord, we have got the instructions today morning, my lord. My lord, we are just seeking time till Wednesday, my lord, to affirm the affidavit and file before lordships.
But one affidavit was filed, but I do not know, it has not been filed, a copy has been served. We have prepared a reply, not by my learned friend, by the erstwhile advocate.
Just
they'll
got the
probably
instruction today.
reaffirm the same.
We just got the instructions today, my lord, today morning, my lord.
No, if there is already a copy served, why don't you reaffirm the same instead of going through that entire exercise? That will.
This is the opposition which has been served, my lord. We have also prepared our reply long back.
So let him reaffirm and give it, then both can be considered. If you you have been given some instructions. If the instruction is in any way at variance with the affidavit earlier served, then there may be an occasion. If it is the same, you get it reaffirmed.
I think only the person who will, the deponent will, the name of the deponent will change. Because that person.
So reaffirmation may be required, maybe not.
That by Tuesday, my lord, Monday there is some
All right.
difficulty on part of the client, but I'll do it Tuesday and Wednesday, my lord.
Not today. It will be taken up on Tuesday.
Tuesday, my lord, and they will affirm, my lord, if it can be kept on
Why Monday is not a good day?
Monday, my lord. I told him to come on Monday, but he said there's some.
Let's see if it is not done by Tuesday. You please tell us. We'll
Monday, my lord, I will try to Tuesday, my lord, try to do it in the morning so that if it is called Passover Sunday, I can file it.
If there is some difficulty on that day, we'll adjourn it for that.
My lord, deeply obliged, my lord.
Item number 8, my lord, I have for the petitioner. And I hate it. But one soft copy was been served upon me with regard to the opposition they have their file without any signature. Soft copy has been served.
Of opposition?
Opposition, my lord, without any signature or any other thing, my lord, but that has been served. Mr. Guddu Singh was appearing for the respondents, my lord. This is that matter, my lord, where the petitioner was been dismissed from service. My lord, although he do have the requisite qualification of class 10 pass or Madhyamik pass, but in what has happened, my lord, he has in the application form he has mentioned he has passed the school matriculate examination and the higher secondary examination, also the BA examination. Now, later on, it was found the degree which was given to him in BA is, my lord, effect 1. But thereafter, my lord, show cause notice was issued and he was been dismissed. So, my lord, there are two contention. One is, my lord, I do have the requisite qualification. That one part I do not know. The certificate issued by the Jodhpur University is to be effect 1. The other one is, my lord, I may say, my lord, subject to I leave without proceeding. Dismissal is, my lord, stigmatic. I was a professional, my lord. They could have done it, my lord. This is the second other point. Petitioner, Guddu Singh's name. Well, if your lordship takes up page 43 once.
So you were appointed as a sub-inspector.
Sub-inspector in Food and Supplies Department.
Then what happened?
My lord, my lord, the requisite qualification was class 10 pass. I made the PVR wherein I mentioned, my lord, class 10, class 12. In the form, my lord, I mentioned class 10, class 12. In the PVR, by that time, I accrued a degree from the Jodhpur University, Bachelor's of Art degree from Jodhpur University. My lord, I also annexed that document. Later on, it was found that that degree is a fake one. My lord, thereafter, the issue of show cause notice, and my lord, they have dismissed me, stating that you have placed a fake degree while filling up the PVR. Page 51 is the impugned order, I may say, my lord.
What is the date of filing of the OA?
8th of August. Your lordship will find one stamp, 26th of August, sorry, my lord. 23. Stamp by given by the learned tribunal is on 26th of August, 2025.
So tell us, what is the law?
My lord, your lordship is asking me. My lord, your lordship is asking me.
Yes, so the facts of your case is the minimum, the educational requisite qualification you possessed. You have thereafter in PVR mentioned a higher qualification. You say it is of no consequence because even if I did not have that qualification, I was qualified.
Absolutely.
This is your case. So in such a circumstance, when you don't dispute, deny that a wrong information was given in the PVR, the fact that it was of no consequence, what is the law?
My lord, subject I understand what your lordship is saying. But my contention is this, my lord, the certificate which I have obtained, the degree certificate, my lord, is in a distance course. My lord, I don't have to go to Jodhpur and my lord, take the my lord, this course per se. But I was of the impression, my lord, the certificate is to be genuine. My lord, there is no reason to disbelieve a certificate issued by, my lord, their stamps are there, my lord, it's not possible for me also, my lord, when I applied the distance course and I got a certificate. But later on, when the PVR comes down, I came to know that certificate is to be a fake one. But my say, my lord, if I have done anything, my lord, that is done in good faith, not in, my lord, any I may say, my subject lordship kindly, my lord, with any malice intention. Had that been malice intention, I would have placed it then and there, my lord.
So therefore, no malice and of no consequence, both.
I will say, I say, look, without any malice, my lord, I've done this, my lord. There's no malice attached to me. And my lord, the other party, your lordship may take note, my lord.
How the authorities can determine whether it was based on any malice or not, and are they required to go on this exercise, or they have to consider the PVR objectively?
To be candidly speaking, my lord, the second part of your lordship is right. They have to go to objective to the PVR, not whether
So
this.
therefore, we are asking you, where is the scope? Where is the law? Please show us what the court right from the judgment in the case of what is that 2018 judgment.
After seeing your lordship is referring to
Avatar Singh. Yes, now it has recently also that has been considered. So there is a what is to be done is enumerated by the apex court. So let us see.
I don't have
fall in which category?
I don't have the judgment today itself, my lord. My lord, your lordship will take it up any other day.
Avatar Singh and the latest judgment. Recently also Avatar Singh has fallen for consideration.
But your lordship is saying those judgments which are against me, my lord.
Actually not. See, that's why we say it enumerates the various circumstances, the stage at which the occurrence took place, whether there is intention, what is to be considered, what is not to be considered. Everything is there. We have to go by the law.
That's true, my lord.
It's not that sitting here we can direct anything.
No, my lord.
So have a look what it says.
I will come back to the judgment if frequent, my lord. Lordship kindly adjourn it.
The long and short of it is that there is no malice, as you claim, and the second is it is of no consequence.
Yes, but this is
because even if that degree is ignored, you still are qualified. This is your submission. So what is the law?
And
Avatar Singh, there are two judgments. In the latter judgment, it is all enumerated, the circumstances. It is a shorter judgment. So we may proceed on that basis.
I will come back.
Plus, there is a more recent judgment after Avatar Singh.
My lord, I
We will
will
not
check.
tell you, you find out.
I will check, my lord. I will check, my lord. The other thing, my lord, is another point is also there, my lord. But I was a probationer. My lord, they say, my lord, the provisional appointment said the appointment would be cancelled. My lord, they went up to make a dismissal order. But
No, because they gave you a show cause.
yes, but they give show cause, my lord.
They gave you a show cause and you admitted.
Yes, but that's true. I cannot deny it.
Therefore, it has to be stigmatic.
I understand. Maybe I'll come without after. Let me go through, my lord.
Lord the learned advocate for the
But it will be on Monday, my lord, 2 weeks.
2 weeks.
It will be Monday or Tuesday or Friday, my lord.
They'll give you the date.
Friday, Friday, 10th August. Monday. Let that be on Monday or Tuesday, my lord, the normal days.
10th.
10th.
Item number 9. My lord, Mr. Achil Kumar Mojumdar, my lord, appearing for the petitioner, my lord. He is ill, my lord. Kindly note today, my lord.
My lord, I am praying for 1 week adjournment, my lord. Mr. Tiwari appearing in this matter, one of his family member has expired.
As jointly played list after.
Madam, appearance, sir. Appearance.
Please give your appearance.
Item number 10.
Sir, I'm appearing for the appellant CSC Limited, Dr. Shaharai. Pursuant to your lordships, last direction I'm filing this affidavit. Your lordships wanted to, the document, to see the document by which he was informed that there is a case of splitting loan. But that's at page 5 annexure E. After judgment point. These matters, my lord, at that point of time, that was the views of the honorable judge, single judge. My lord, we take out several appeals, and my lord, we succeeded on those appeals. My lord, I can cite, my lord, the order of the division bench. At least 2 matters we had the judgment. And 4 both.
No, the only issue is the regulation requires you to communicate the decision.
That we have.
We don't think so. This is just a letter. We neither see that it was served nor there is any dispatch.
Your lordships, in the impugned order under appeal, this was mentioned.
Where is it?
That's your lordships. Kindly have a look at page 34 of this application for stay.
Yes.
The very first paragraph. 16th September 2019. That's the letter we have annexed, your lordships.
No, that was not on the record earlier.
Not that, because this was on the motion stage, it was taken up with total honorable judge.
So then you have asked him to go before the regional manager.
Exactly, GRO now.
So has he done
Now,
that?
my lord, it is all that, but my physical instructions today, my lord, that this was, supply was in the name of the father, daughter was asking for the same premises, father is no more.
Oh.
Daughter and mother using the same meter.
So that's why perhaps nobody is appearing.
So, my lord, that's the present situation. So
No.
it's no longer needed also probably.
Did they appear on the last occasion?
No. So your losses can give them liberty if they want. Probably that
In their absence, how we can do it? We had on going through the records, we wanted to verify whether there was a communication or not. So since there is a communication,
I'm told he has communicated.
no, we have understood from the order.
No, that communication, even this appeal we have communicated to them.
So
that's the affidavit of service. I am not checked up, my lord. I just handed up your losses.
No, we'll not rely on this. This is of 21.
It is the department secretary. This appeal has come up before your lordship from the department. So we had served the notice. We watched the list. They are supposed also to watch the list.
No, unless they represented already, how they can watch the list?
No, I have served upon the learned advocate who appeared before this honorable secretary.
Whether he still appears, nobody knows. I don't know. I have seen here in many cases you say we have served. How do you know that he will appear here also?
He has accepted, otherwise he could not have accepted it.
Oh. He has accepted.
Accepted that.
So where is he? You ask him to come.
I'm told personally he has told Mr. Haldar, but they are no longer interested. But probably he is no longer interested. And so far, the read petition also refers to our order, communication.
No, that you have just shown from the first paragraph.
That's the order, but the read petition
In the
itself,
petition also he has stated.
Paragraph 5, your lordships will get it of the read
No,
petition.
but whatever it is, there is an order now which he may seek to derive some benefit on. In his absence, we will not pass any order.
At least your lordships, this has to go before the GRO.
Before the
grievance redressal officer.
As per regulation.
Nothing.
Unless the order is set aside, can we do it?
No.
Therefore, he has to be here. Let him be here. Then, if he is not interested, issue a notice on the petitioner himself.
Long gone. That's long gone. We have to do it.
What can be done?
Losses recorded.
See, this disposal may generate an unnecessary litigation. It's better to do it after.
I get it.
Yes. The
Seventh.
that may not be required. Let's see when they come. May not be.
August.
7th August.
Item number 11.
None appears on behalf of the petitioner.
Item number 2.
Lordship, I am for the appellant and praying for adjournment since I'm not telling that unrecorded matter, somehow the matter was pending so long and somehow the brief has been lost from our custody and we informed the appellant, but she is a ailing lady and suffering from some gynecological problem and almost bedridden. She couldn't be provide to the same further and praying for adjournment at least for 2 weeks. But until and unless the brief is
You are the advocate on record.
no, I'm the junior of the advocate on record.
The learned,
Weeks, 14th August.
14th August. Grateful, madam.
we have sent it to the department. You get a certified copy. Don't pray for adjournment again.
Okay, my lord. Since the appellant is suffering from disease,
Even if she is not there, you get the certified.
he will provide. Told us.
For the adjournment.
Item number 13.
Same order, this is 44. On earlier occasion, there is 10/7/2000.
Item 14.
Same order.
Item 15.
Same.
Item 16.
So we'll record that you have not been able to get any instruction. We are informed by the learned. Dismissal in defaults, you give your appearance. State is represented, you record that state is represented.
Item 17.
Dismiss for default.
Item 18.
Dismiss for default. Dismiss for default. 18. Same.
Item 19.
Same. 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 Same.
Item 21.
Actually, I am appealing for the performer respondents.
I am for the respondent bank.
Item 21.
Performer respondents, Union of India.
I am for the private respondent. Led by Mr.
Who is for the appellant? Who is for the appellant?
Bank of Baroda, we are.
You are.
Yes, I'm for the appellant bank, my lord. There was a on the last occasion, Mr. Dotto has appeared, and there was a direction to give a supplementary affidavit. My lord, by the time it will be done, my lord, today itself, my lord.
There is no such direction.
My lord, Mr. Dotto has appeared on the last day and said that.
No, sir. There is no direction for supplementary affidavit. On 21/1/26.
In that case, my lord, kindly state, my lord, will file in between, my lord.
You are a bank,
Yes, sir.
and this is the way you are just getting adjourned. An appeal, this is the fourth adjournment.
Unconditional apology, my lord.
You are not interested, then why you file these appeals? On last date, we were informed that this person against whom LOC is issued has gone abroad and come back. And we asked you what apprehension you have now. Today you are again trying to turn the clock back by saying that we'll file a supplementary affidavit. Not today.
Item 22.
Yes. Last occasion date 10/7.
Item 23.
Last date बता. Last date.
Item 24.
My lord, we are for the respondents. Last occasions also they didn't take any steps. Possibly, my lord, they are not interested.
The WSEDCL is represented.
Yes. Great. Great.
Did it? 20.
Same.
No.
26.
This.
Regarding item number 21, I was the private respondent. One humble prayer, Not today, my lord, gave it not today, not today, it will come on Wednesday. But can it be on?
Let it come on Wednesday. Sir, after the lawyers are gone, then you have come to mention. We don't know of such a practice. Sorry, call the next.
I'm
This is not the way that you can come up whenever you want in the midst of proceedings to make a mention. It is least expected is you'll wait for the rising time, have the other side here. What is this? This is SDO code that you will come and say whenever you want.
No, I'm for the WBACPCL led by Mr. Sujan Naik. Same thing.
Space for default. Take the appearance.
Item 28. Item 29.
There was a prayer for area rent with interest. The court had granted the area rent, not the interest. Appeal by the Union of India from that order not had failed. So we were paid the area rent at the revised rate, but this appeal for the interest claim.
Well, for the repetition. Why are you agreeing?
For non-payment of interest.
They have paid you the amount.
No, I preferred the appeal before receiving the amount.
Now that chance is over.
That chance is over.
How many months the area was there?
94 to 21, roughly 27.
There was some dispute pending.
It was the issue was with regard to the rate of rent.
Tax.
Rate of rent by the taxing the CPD, I mean the Commissioner of Income Tax. Now the peculiarity of the position is this: here the tenant decides the rent, unlike a landlord deciding the rent. Now the tenant decided the rent to be at a higher rate, which the Income Tax Department was not adhering to. CPWD had prescribed a particular rent at the revised rate.
But finally, the court said yes.
You have to follow the
other thing is they were saying that you are required to pay the tax and all.
That's not in dispute where we have paid them.
But due to that dispute, also the amount could not be.
The amount was the area was rent was only for that revision. What would be the revised rate of rent?
Otherwise, they were paying the rent.
No, we were receiving the rent. I was the owner of the premises.
That's why we are saying. Otherwise, they were paying the rent.
They were paying the rent at the pre-revised rate.
Pre-revised rate.
But CPWD had revised the rate at a particular revised rate, which they were not paying.
And they, based on such revision, in the next agreement, you wanted a revised rate. They said we will not execute because tax and all has also to be discharged by you.
Yes.
So all this became a issue. Since there was an issue, why they should be saddled with an interest?
But as far as the taxation issue is concerned, once again it came on the basis of not the revision, the general valuation of the area. And not the rent would decide the tax. We had paid at the area rate, unrevised rate.
India was represented earlier.
Yes, not the learned, the erstwhile learned advocate, additional solicitor general had represented.
Last day there is nobody's appearance when we have allowed the substitution.
Thank you. Oh, before your lordship's court, they have not appeared.
Prior that somebody was representing. In the
No, in the appeal, in this appeal, no, none has appeared.
So the issue, sir,
And it-
let a notice be served on.
Item number 30.
My lord, he is better. Mr. Sarojit Singh is appearing. My lord, I am praying for not today, my lord. Not
Item 31.
I praying for not today, my lord.
all the technical service.
32.
Not
None appears. We stop for 3 minutes.
Item 33.
I appear for the appeal.
Eight respondents.
The other respondents also.
Yes.
Yes,
It would be rather supporting us.
It is supporting them.
33 to 44.
In a very strong position.
So Mr. Vikas Ranjan Bhattacharya was leading the petitioners.
Or what to do? Isn't it? Private respondents are not.
Item 45.
None appears for the parties.
Item 46.
Six minutes. I am for the response.
Rita Pandey is appearing for the petitioner lordship. He's
Not today.
coming from a chamber.
Not today.
At 46 and 59 minutes together.
46 and
59 are two
59.
analogous matters, man.
very well. Both matters not today.
4659.
Item 47,
Lordship, I'm praying for a not today.
Not today.
item 48,
My lord, Mr. Devashisha is appearing for the appellant bank in this matter. I'm bringing for a short pass over.
Not today.
49,
None appears.
item 50,
Item number 50, Lordship, Senior Advocate Pathupatim Rai is appearing, praying for not today.
I was appearing on behalf of the respondent.
Give your opinion.
not today. 51,
There is none to represent the party. 3 weeks.
one second, you look.
আমি
Viraj, 52,
52, I appeared.
None appears for the parties. Oh, state is represented.
item 53,
There is none to represent the parties.
So, Lordship, in respect of item number 51, my lord, I declare for the respondent, my lord.
What makes you think you can come up anytime and say that? Please wait till the court is rising. This is not the way.
I bowed on I bowed.
item 54,
Going on, please.
Well, item 53, my lord, I am for the rest. 53 just now.
4 is left.
53. নামটা দিয়ে দিন
Yes.
Lordship, I am filing affidavit of service with Lordship's permission. All copies were delivered, Lordship. একটা কপি কোথায়? একটা এটা কোথায়? Lordship, my clerk is bringing the copy of the affidavit of service. Lordship, the thing is that in short, I am saying, Lordship, the grievance of the petitioner was that the petitioner, namely Shamoli Mukherjee, was the wife of her deceased husband, but her name was not included. PO. After that, the pension payment order book.
How it can be included? How the name can be included in a PPO? It has to be included in the nomination filed in the service record.
Yes, as of nominee,
Not declared as not.
no, but in official book, the name of the wife of the deceased person was included. Due to that reason, Lordship, the family pension was not disbursed in favor of the petitioner. Thereafter, Lordship, the petitioner sent a representation, and after taking the representation, one hearing was conducted, and in this hearing, necessary documents were called from the petitioner. After perusing the necessary documents, the prayer for family pension was rejected. Thereafter, Lordship, we prefer a writ petition by challenging this rejection order. In the hearing of the writ petition, some questions was thrown on the single bench that what are the necessary kindly show the necessary documents from which it will be revealed that the petitioner was the wife of the deceased person. Lordship, in the writ petition,
They are also throwing the same question.
Lordship, but Lordship, in the writ petition, the learned advocate on record annexed the vital document. From this document, it was shown that the petitioner was the wife of the deceased person, namely Krishna Gopal Mukherjee, and this document was generated before the deceased person. This is the vital issue. Lordship, I humbly draw your Lordship's kind attention on the impugned order that the Honorable Single Bench said that the document which was generated after demise of her husband, but before demise of her husband, two documents were generated. One is the Aadhaar card and another is a copy of SDM. I have annexed the Aadhaar card, Lordship, white page number 54 in the stay application. White page number 54. The document, that is the Aadhaar card, was generated on 2010-2016. Shamoli Mukherjee, wife of Krishna Gopal Mukherjee. Krishnadas Mukherjee died on 12/1/2023, and the document was generated on 20th October 2016. Now, Lordship, kindly come to page number 55. This is the voter ID card. Lordship, in voter ID card also, the voter ID card also was generated on 11/3/1995. And in this voter ID card, the name of the husband is present, Krishna Gopal Mukherjee. Now, Lordship, kindly come to page number 59.
How do you say these documents were generated on such and such date? Where is the date of issuance of the document mentioned?
Lordship, and during the lifetime of the deceased person.
From where do you say that the date of these documents were of such and such date? Where is the date mentioned?
Date mentioned in Lordship? In page number 54?
Yes.
Page number 54, the date has been mentioned beside the name of the petitioner. 2010-2016. May I give a my copy, Lordship? I have highlighted.
Aadhaar card. Aadhaar card.
This is the Aadhaar card, Lordship. During lifetime of, in that portion, Lordship. In that portion.
In the margin, it is printed.
Lordship. And Lordship, kindly come page number 55. Last two lines from bottom, right hand side.
That is age as on. That does not mean it was issued on that day.
That means, Lordship, this is an old voter card. In this old voter card, the name of the husband is also present, Lordship.
So this is enough according to you for getting a benefit of pension.
And Lordship, another order, Lordship, page number 59. The order passed by the collector. Point number 7, Mrs. Shamoli Mukherjee, wife of Krishna Gopal Mukherjee.
This was passed in which proceeding?
Legal heirs, Lordship.
Why such an order was passed by the collector?
Actually, Lordship, the father of the petitioner was the government staff, and due to that reason,
husband of the petitioner.
Husband. I'm claiming the pension of husband. But before marriage of the petitioner, the father of the petitioner was alive, and the father of the petitioner collected this order, which order was passed by the collector Bardhaman.
Yes, sir. So on this basis, you should be granted the pension.
Lordship, subject to Lordship's correction, the order which is impugned in nature before your Lordship, in this order, the contemporary documents were required, and Lordship, the Honorable Single Bench asked that kindly show one document which was generated during the lifetime of the husband of the petitioner.
That you have already said. So we are asking you, on the basis of these documents, you can be granted the pension.
My humble submission is that, Lordship.
Very well. That's all. Take down. Heard the learned advocate.
or the rest.
Call the next.
Item 55.
The appellant, your lordship.
Yes.
Your lordship, by the impugned order, my writ petition seeking appointment on compassionate ground was rejected because, my lord, we had applied 4 years, that is after attaining majority, my lord, relying on an order of the Honorable Supreme Court of India, your lordship. Now, my lord, distinguishing that judgment, it could only be done subject to there being some provisions, my lord. Now, the West Bengal, your lordship, directions under which I had applied. Initially, my lord, when my father had died, it was me, my mother, and my married sisters, my lord. There was no objection by the married sisters. My mother was at that moment not medically fit. I was the only eligible candidate. Now, when I had applied, it was initially rejected. And then, your lordship, I had also sought for reconsideration on the ground that I was the only eligible candidate, my lord. Subsequent to the first notification, there was an amendment, my lord, by which belated requests on special circumstances were considered. Now, under clause 10AA of that notification, my lord, upon consideration of those belated requests, your lordship, the matter was sent before the concerned department of the government and the matter was pending since 2023, your lordship. That is when we had also sent a representation for passing an order with regards to my compassionate appointment. Since there was a delay and no action was taken on part of the authorities, your lordship, we had filed the writ petition.
So in your writ petition at page 27, it starts from page 26.
Yes,
Where have you stated that your mother was not eligible candidate at the time of demise?
Your
So as
lordship,
to invoke 10AA of the notification which you will probably rely upon.
your lordship, the authority had only considered. Kindly takes up, my lord.
No, where is that averment in your writ petition that your mother was not eligible and therefore she could not apply?
My lord, I had stated that subsequently upon my reconsideration.
See, there are two things. You are relying upon a notification 26.
Yes, your lordship.
26-EMP.
Yes, your lordship.
26-EMP is of which year?
Your lordship, 2016. 2013 was the first and the next one was
So
2016.
2016, your case was rejected.
Your lordship, initially it was rejected.
When?
Your lordship, 2020.
20. Very well. So therefore, if you are relying on 10AA or
Yes.
10BB of that notification, which we think you probably will rely upon,
Yes, your lordships.
in exceptional circumstance, that
Yes,
is
your
what it
lordship.
says, up to 5 years.
Yes, your lordship.
So there is two illustrations given therein. One is if there is no other person eligible. Perhaps you are claiming under that clause.
Yes, your lordship.
So where is that essential fact pleaded in your writ petition that there was no other person eligible? When did you inform the authorities that no other person is eligible? So I will apply. That's the only thing you have to show us.
Your Lordship, paragraph 13.
We have
This is,
not
my
been
lord,
able
of
to
the
find it.
stay petition, my lord. Similar pleadings are also there, my lord, in my writ
Again,
application.
we are asking you, when did you inform them after his demise that nobody else is eligible?
Your Lordship, first I had applied after I had attained majority, my lord.
That's
It
why
was
we are
rejected
saying.
in 2020.
So before 2014, perhaps you have applied.
Yes.
So before 2014, your father died in 2010.
Yes, your Lordship.
From 10 to 14, when did you intimate them that there is nobody else eligible,
Your
or
Lordship,
till
that is
15?
that is not on record.
Then how you can claim a benefit under 10AA or 10BB? That's the only thing.
Your
Any
Lordship,
subsequent document will not justify.
Your Lordship, what has happened is, my lord, in the meantime, this is, my lord, what has exactly happened. They had approached and we were requested to apply after attaining majority, my lord. That is what I have, that is what I pleaded also. My lord. In the year 2014, I apply. In 2020, my lord.
Neither their instruction nor an agreement between you and some officer can change the consideration which is to be founded on the policy.
My lord.
Ultimately, the policy has to prevail.
My lord.
You can't say that he asked me to do this, therefore I did this.
My lord,
After the judgment of Devadatta Tiwari, now there is a law which says strictly in terms of the policy.
My lord. My lord,
therefore, if you fall in the policy, you get. Otherwise, an employee of 2010 dying in 2010, directing a compassionate appointment in 26, it is difficult.
My lord, kindly also considers page 56 of my stay petition, my lord.
Yes.
This is issued by the Office of the Commandment of the Government of West Bengal, my lord.
Whatever it is much, much later. How it can certify a situation in 2010, 11, 12? This is of 21. How can anyone say in 21 that in 2010 she was not fit? And how it can be stretched so far?
My lord, there were records. My lord,
What
may
did
I
the
come
Lord
back on the
single
next day
judge
and
hold?
satisfy on this, my lord?
Huh?
Your lordships, may I come back on the next day and satisfy on this issue, your lordships?
Not today.
without certified copy, my lord, this is of my lord, the acting chief justice's jurisdiction. Your lordship has the determination today.
Subject to usual 100, but why you are mentioning today? Mention when his
My
lordship
lord,
is
in the morning, my lord, when we came to know that your lordships had the determination already, your lordship.
We have been authorized to take up urgent matters. Filing, you can file it on Monday.
Only the leave, my lord, without certified copy.
It is better you take the leave from his
Want
lordship.
to move it on Tuesday, otherwise, my lord, if Monday we get the leave, my lord, it will get delayed.
We don't. If it is a matter on the list, it is urgent, can't wait for the day, then we'll take it up. Otherwise,
I understand.
sorry. Yes.
Item number 61, matter.
In item number 61, I am paying notice on behalf of Mr. Dhiraj Trivedi, my lord. My lord, one constitution bench.
All right.
And my lord, kindly fix it. Both of us agreed, my lord. Kindly
Not today does not mean fixing. Not today means not today.
Today.
Yes.
My lord, both of us agreed to fix this matter on
Not
30th
today.
July, my lord.
Not today.
Or kindly fix it on 30th.
You start. We'll take it up right now. Give.
Well, then not today, my lord.
Yes, not today. You can't have both ways. Yes, call the next.
Item number 56.
Time for the respondents.
না স্টে করিনি স্টে তো না My lord, through I am the petitioner, applicant, my lord, in this matter, my lord, challenging the appeal order by the single bench. The brief facts of the case is, my lord, the petitioner applied for the post of constable CAF. There she was rejected on the grounds that she is having some cut marks. Based on these cut marks, which is called the vegetation mark, I have been disqualified by the psychologist.
Shows the report of 24th February.
Report of?
Shows the report of 24th February.
Report filed by.
Read paragraph 4 of the writ court order.
Read court. अच्छा, तो that you should do. ठीक है। अरे ये तो आप लोग लेकर आओगे ना अच्छा ठीक है ठीक है पिटिशन है पहले दोनों एक नंबर इसमें 1 2 एक्सेप्शन हाँ नो नो दिस इसके बाद ये 3 एक्स
Yes.
My lord, I was analyzed by the different psychiatrist at the government hospital.
No, nothing beyond the record. Nothing beyond the record.
It is in my writ petition, my lord. That
Whatever it is, this is the
my respectful submission before my
medical
lord.
board and review medical board. DME and RME, that's all.
Yes.
Nothing beyond DME and RME. What are you handing us?
My lord, I'm going. My respectful submission before my lord is that based on this hesitation mark and cut mark, they have rejected my candidature, and number of candidates are being rejected. With this presumption that if I first these were not the self-inflicted injury, none of their statute or the guideline says that this cut mark or hesitation mark subsequently leads to the mental illness of a person. I'm just placing for my lord the Mental Health Care Act 2017, the one portion. I'm just coming. My lord will kindly see the section 13, section 3. Do to copy. The last is, my lord, section 3. May I read, my lord? The determination of mental illness. My lord, the paragraph subsection 4, paragraph 3. Mental illness of a person shall not be determined on the basis of A, B, and paragraph 4, my lord. As treatment, speculation. Last is, my lord. Section 3, subsection 4. Substance shall not be determined on the basis of specialization in mental health care establishment through relevant that are not by itself justify determination of the person's the person is of unsound mind, he has been declared by such competent court. These are the 2 points, my respectful submission before my lord.
Challenge the guidelines under which you were declared unfit.
My lord, they means they could not produce any guidelines.
They could not produce. It is a public document.
My lord, there is no whisper about
It is available on the website, sir. All these guidelines are available.
I have the guidelines, but there is no whisper about the hesitation mark and the cut mark.
There is no whisper.
There is no whisper about the hesitation mark or the cut mark.
No, that's not the point. You have admitted that it was self-inflicted.
No, I have not admitted it.
That you may say, you will say, we know that, but you have admitted.
My lord, it was never admitted because she was a Bengali girl. She said, "ये किसने किया, खुद किया है, किसने किया है," and whether it is self, that should have been taken on affidavit. If at all, my respectful submission is that should have been taken on affidavit for
For every candidate, the recruitment agency will start doing this. They will never be able to complete a recruitment. They have to go by set norms. It is done for every candidate uniformly. You cannot expect anything more than what is being done for others. There is a DME, there is an RME. There is an opportunity to challenge it. In RME, you have accepted, you have signed without any objection. Then in court, you say, I don't know. And this
my lord will kindly appreciate during the recruitment process, there is a huge crowd. Even the candidates.
So everything has to be looked into by the court.
My lord, my lord, I am only before your lordship is that based on the I am pointing out that
You want to serve an armed force. There can be no compromise whatsoever.
I'm not.
And there's no scope for any leniency. It's not a general appointment.
My lord.
Taking appointment in which force?
My respectful submission before my lord is that I'm the statute, if I can satisfy my lord, that there is the hesitation of cut marks. Can person
repeat that you have already said. That you have already said. Yes. Take down. The learned advocate for the Please leave a copy of that report.
Copy of that. My lord, I shall give. The report.
Item 57.
For the response. My lord, for the item 57, similar matter, my lord. I was rejected because of the hesitation mark. Even my mental exam, even I had conducted my mental psychological test by the different psychiatrist to the government hospital. That psychiatric test makes me completely fit. I have not been declared unfit by the psychologist. Page number 23 of my writ petition. By the JNM college, I was declared fit on the similar grounds.
Cannot be taken into consideration. What is your explanation regarding the marks here in the review medical examination?
These are not the self-inflicted injury. I
Let
have
us see. Show us the RME, DME, RME. This is not legible. Give us typed copy. Complete this. This is the DME. RME is not legible.
RME, may I hand over? I'm sorry, it is that.
No, we cannot decipher. You have to give us typed copy. Report was submitted.
Report was submitted.
You file a legible copy of the report. You place a legible copy of the report. Let the legible copy of the report. Legible stroke typed copy.
Actually, item number 58, I appear for the appellants. I am seeking a not today. Adjournment.
My lord, I appear for the respondents. I have no objection to it. Grateful.
Grateful.
60.
It is the application, my lord, is the interdivisional order of transfer of a medically decategorized constituent. My lord, while working at a RPF constable, my lord, I was very seriously ill, and my lord, due to neurosurgical disorder, my lord, I was sent to Chief Medical Officer, Howrah Division. The Howrah Authority, Howrah, Superintendent Howrah Authority, my lord, declared me medically decategorized. Thereafter, for revision, my case was sent back to my lord, Bengal. Your lordship, I'll see annexure P1. Annexure P1, page 20.
You are coming against rejection of stay.
I am, yes.
Go there before the report.
My lord, either my lord, I grant stay order, my lord, then I will have to join the.
You have to. Why not?
I am a medically decategorized.
So they have given you a job where you don't have to use such a.
He's here for 15 years at a stretch.
When the medical.
Will not take it into consideration here.
15 years.
Before the report.
My lord, 1 minute.
10 minutes. Why 1 minute?
Yes, yes.
10 minutes.
Yes. Let's say kindly come to annexure P1.
Yes.
This is a review medical board's order.
So why we are going to look into it? That's the issue. What is the order passed by the report?
Well, the medical authority.
Every order we will sit in appeal, in a intra-court appeal.
That is not medical authority.
Why we are going to look into it, sir? Please try to understand what we are saying. You may have the best case. You will succeed before the report.
Malad, when the three medical authority
will succeed before the writ court. Why we should hear it as if we are hearing the appeal writ afresh? Why we should hear?
Writ court refused the stay order.
Rightly so. They have considered your condition and given you a posting accordingly. Go and join that post.
Malad, I have never been given a suitable alternative job.
We don't know. We will not look into that.
When the Malad, your loss of policy, annexure P1.
There's nothing. There's nothing.
Loss of policy.
When is the next date fixed?
No date is fixed.
Because she gave you liberty to mention you are here before the division bench.
Lordship.
You are procrastinating the matter.
Can you see the order? Order of the writ court.
Yes, please read.
Page 2-3.
Yes.
Let the respondent file an affidavit in opposition to the petition within a period of 6 weeks from date.
Yes.
Reply penny may be filed within a fortnight thereof.
Next paragraph.
Liberty to mention the matter.
Yes. Instead of doing that, you are in appeal.
After completion of the aforesaid period.
Then why you are here?
During this period, my lord, where I will stay, my lord? If stay order is not passed.
You don't know. That will be decided in the report.
No. Lots of kindly consider one thing.
Yes, which annexure you want us to
Lots of,
P1, what do you want to show from P1?
lots of statutory rule is violated.
No, we are not going to hear it as if we are hearing the repetition. Please be very sure that we are not going to hear it as a repetition. Why the interim order is bad, tell us. Why you should not go and join a post during the pendency?
Lots of kindly come to statutory rule.
Why, sir?
Rules. Well, a rule provides
Yes.
that if the person is medically decategorized, he will be given an alternative job.
They have given you alternative.
Yes.
No alternative job have not been given.
They have given you. It has been recorded in the single judge order.
I have been written as a RPF constable.
You read what is the alternative job they have given you. Show us. Where is the posting order?
CLW, one Chittaranjan Lekun. The hospital is there. Yes.
RPF constable.
Yes.
I have been declared unfit for RPF constable.
Yes.
I was B1, declared B1, unfit for B1 category.
Very well.
I am.
Only see there is some mental incapacity. There is some mental incapacity. There is some mental incapacity. Therefore, they have said that they will not give you an armed posting.
Yes.
They have put you on a post without arms. You see, put you in some other office. They will consider. So the writ court will consider it has not been rejected. Why we should hear it?
Statutory rule says.
Maybe we are not going to go into that. It is yet to be decided. Why we should go into it?
We will not consider by statutory rule.
No, surely not. Unless it is decided by the writ court, we will not.
Writ court, when the writ court will hear the matter.
Every matter we should take up in LPA. Why not? Sir, you can't make such submission that you are asking the court, you will not consider. No, we will not. We are not supposed to. The appeal is against an order deciding a dispute, not against every order passed by the writ court. What is the law? Tell us. Every order you can challenge in an inter-court appeal. What is the issue decided? Just because you have filed, we have to go into everything.
Kindly come to P9 statutory rule.
Yes, you read it.
abduction of disabled medically decategorized staff in the alternative appointment. A railway servant who fails in vision test or otherwise by virtue of disability acquired during service become physically incapable of performing the duties of the post which is occupied should not dispense with or reduced by rank but should be shifted to some other post with same pay scale and service level. Then your loss will come to 1003. This is very important. The railway servant was in group 1 and group 2 of para 302 above C to perform duties of post. They are holding from the date they are declared medically unfit. I am declared medically unfit. In three authority. But
Not by the medical board.
no officer has the authority to permit, no officer has the authority to permit the railway servant concerned to perform the duties in the post beyond that date. If such a railway servant cannot be immediately adjusted against or absorbed into alternative post, he may be kept on a special supernumerary post in the grade in which the concerned employee was working on a regular basis before being declared medically unfit, pending location of suitable alternative employment for him with the same pay, stay and service benefit.
We are asking you repeatedly to show the transfer order. You are reading this. We are not going to go into this.
Instead of
Where is the appointment order? Your transfer order. Where is the order?
Yes.
See, there is only one protection to you, that you cannot be reduced in rank and status. As a result of the incapacity, you cannot be prejudiced. That is the only right you have. Now show us the transfer order.
And it's a P10. Yes, 30.
Page 30.
Zero. This is the input order of annexure. Last time come to the serial number 38.
One.
Serial number 138, page 36. Yes, 36. 138. Serial number 1, Constable pay scale 3. Howrah Value Staff Yard Post, Howrah Division. To Chittaranjan locomotives.
Works.
Work. Harmful company such and such. So, why the transfer order was made? Instead of posting me a suitable alternative job.
Very well. Take up. Heard the learned.
A coordinated bench at the similar point. Okay. Kindly come to paragraph 22. And after 22, my lord. After having reached the permission of paragraph 1303, stated above, we are of the view that once a railway servant is declared medically unfit, he has to be given a suitable alternative employment. But before that status is confirmed, the person concerned has to be kept on the supernumerary post. He cannot be subject to re-examination. He can be ordered to be examined in accordance with law by the concerned authority only. Those departments in which such medically declared unfit person is observed in an alternative status in terms of paragraph 1303 of the railway service. So once I have been medically declared, what transfer is necessitated? Instead of considering my alternative suitable alternative job, when the rule provides 1303, and so long, my lord, my alternative job will not be concerned. My lord, my scope of promotion in the alternative post will be
Yes, that's all.
And my lord, the learned judge did not consider the statutory rule, the point, this judgment.
Take down. The learned advocate. should have expedited it there. Unnecessary you have.
Lastly, it is submitted